YNW Melly's team has filed another motion to dismiss the entire case, which is an 18-page document that details how they found out that the phone records was tampered with in the first trial. The state also filed a motion to get rid of any jurors who thoroughly researched the first trial on YouTube. Yeah, a lot of motions and being filed, but apparently there's a live stream tomorrow, so I'll be, covering that as well. If you're new to my channel, subscribe on my Twitter and Instagram. Let's go right into this, boys. All right, boys, the first thing we got right here is order on state's motion for inquiry of all pre-qualified jurors and motion for relief. The state alleges that the defendant's mother, Jamie King, had improper contact with certain pre-qualified jurors and asked this court to institute measures to protect prospective jurors from further interference, relying on the Smith v. State, Florida 2009. And then it says, court hereby orders Ms. King to stay away from all prospective jurors and from any areas where prospective jurors are likely to be present at a given time. Ms. King is ordered not to have any contact with prospective jurors, whether verbal or non-verbal. Ms. King agreed in open court to comply with these above directions. So yeah, obviously the judge is going to grant this because he can't have the fucking jurors being fucked with by the defendant's mother in any way, even if it's apparently not true and she was just minding her own business crying. Like, you still can't do that in front of jurors, obviously. So, and then here's the next thing. State's motion to strike all jurors for calls with significant knowledge of the previous trial. So they're trying to get any of the jurors that know anything about the trial being streamed or any information. If they saw anything on social media, they're gone, obviously. So defendant went on trial in April 2023 and lasted several months. Hung jury 2023. Because the defendant is a well-known rap artist, his case has received a large amount of media coverage on television news as well as online social media websites and YouTube. Defendant's first trial was live streamed on numerous online platforms including Law and Crime and a Facebook page. In addition to the trial being live streamed, subsequent hearings regarding the case were live streamed as well. Live stream means all aspects of the hearing were able to be watched by anyone, just as if they were in the courtroom watching. Defendant's new trial has begun and is currently in the pre-qualifying stage of jurors selection. While this phase mainly focuses on time qualifying jurors who can sit for a significant period of time, it also includes asking jurors if they know who the defendant is or have heard of this case. During this pre-qualifying phase, some jurors have informed the court that they have watched the trial and have done significant research on the case thus far. Yeah, it was obvious a lot of people are going to know about this trial, and I was always wondering how they were going to maneuver that. So the state wants those people bye-bye, clearly. So now they start just citing a bunch of cases where this situation occurred in, and then apparently in this one, defendant's initial conviction and death sentence was reversed, and just before jury selection and the retrial, local newspapers published inadmissible and prejudicial information about the first trial. Because of the timing and content of the newspaper and articles, the statements made by those prospective jurors that they had read newspaper articles had formed opinions about the case. Examination of these prospective jurors was compelled. So in this Ballin v. State right here, the defendant's initial conviction and death sentence was reversed, and just before jury selection and the retrial, local newspapers published inadmissible and prejudicial information about the first trial. Ballin appears to expand on Boggs, holding that even where the jurors had not formed opinions based upon media reports, individual voir dire was still required. Even though these jurors, unlike the challenged prospective jurors in Boggs, stated during voir dire that they had formed no opinions on Ballin's guilt, there was no individual voir dire with specific questions concerning the jurors' knowledge of newspaper articles containing inadmissible and prejudicial information. Thus, the defense counsel, the trial judge, and the court are left to speculate about what these jurors had learned from the newspapers. Okay, yeah. In other cases, this has happened where, some media outlet put out information about a previous trial. They had to really question these jurors and see what they learned about the case and see if these people formed any type of opinion towards Melly, the prosecution, the state, his lawyers that he already has. Like, there can't be any preconceived information, pretty much. State requests that any juror who has filed the case on the news or social media research the case or watch the trial. Subsequent hearings, as it was live streamed daily, be struck for cause, as the state is unaware to date as to what evidence will be introduced by the state at trial. Due to the fact that the assistant state attorneys on the case are brand new after the course removal of the assigned prosecutor and are in the process of learning the case, let alone deciding what evidence to present. Jesus. Furthermore, there are approximately 30 outstanding motions that need to be heard by the court, many of which were not previously filed for the first trial, and which could affect the type of evidence permitted at trial due to the unknown. Having any jurors with significant knowledge on the case should be avoided at all costs. In comparison, the state does not seek to strike for cause any jurors who have simply briefly come across the case on the news or while scrolling through social media. So it's not just anyone that, briefly did it. It has to be someone that really was looking into the trial, apparently. Having jurors with significant knowledge of the prior trial could be detrimental to the defendant. A juror potentially could have seen evidence admitted in the first trial that is subsequently suppressed or simply not introduced by the state. Yeah, I mean, this is common sense to me. This shouldn't be a thing. I mean, anyone that was significantly researching the last trial or is a fan of Melly should not be on the fucking jury, like, period. State's response to defendant's motion to re-depose Detective Mark Moretti. Yeah, as you remember, they want to re-depose Mark Moretti because apparently during trial he talked about more phone information than they got to ask him. So they're like, wait, what the fuck? You're talking about that? We want to question you about that before you talk about it at trial with the state. So they're trying to re-depose him. Doubt doubt it's going to happen. Let's see what the state says, though. Defendant's motion is legally insufficient. Fails to provide any legal basis as to why the re-deposition should be permitted. Is merely conclusory and fails to demonstrate the good cause required. State's basically saying, fuck no, it's not deserved to get a re-deposition. Defendant wishes to re-depose Mark Moretti in regards to cell tower location information, mapping, and data generated from health records. Information was available and disclosed prior to his first deposition. Ooh, so they're like, yo, you had your chance. You already knew we were going to talk about this with him before you deposed him in the first place. Defendant makes a vague allegation in regards to discrepancies between his testimony and the actual evidence, but offers no specific allegation, example, or offer of proof. This also does not constitute good cause. Defendant also contends that Mark Moretti solicited a BSO deputy to commit perjury. However, Detective Moretti is not currently under investigation by any agency for alleged misconduct in 2022, and the Miramar Police Department Internal Affairs investigation did not substantiate the complaint. Further, any testimony in regards to any alleged attempt to solicit perjury is not relevant to the case at hand. Moretti's alleged conduct in a separate criminal investigation in 2022 is unrelated to the defendant's 2018 case. Ooh, so they're gonna fucking try to get rid of... Wow. So the state is saying they don't want any of that in the trial as well. So they're clearly going to object to anything that is brought up about Moretti twisting Mellys Mom's hand. That's going to be interesting to see. Defendant cites no legal authority for the admissibility of such evidence. To the contrary, the case law is in overabundance that this prospective testimony is in fact inadmissible. This matter is very factually similar to Jackson Supra, which was determined not to satisfy the requirements of admissible evidence. So she's stating other cases in Jackson and Supra because the information demanded by the defendant is legally inadmissible and irrelevant based on the case law and statutes. As noted above, there's no legal basis to redepose the witness either. Defendant seeks this deposition in order to potentially impeach Mark Moretti. Wow. This is what is known as collateral impeachment. So this was literally filed a few hours ago. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of defendant's due process rights. Oh boy, here we go. So they're asking to dismiss the entire case again. Let's get it. October 12th, the court quashed the subpoenas for State Attorney Harold Pryor, State Attorney Falk, and State Attorney Killoran. Defense therefore unable to call these three prosecutors as witnesses. For offered what the defense anticipated their testimony would involve. Court then denied motions to dismiss. Okay. Defendant re-alleges all of the grounds in this previous motion to dismiss. The defense has now learned of additional prosecutorial misconduct that individually and in conjunction with motion to dismiss requires dismissal due to the individual and cumulative violation of defense due process rights. Why do lawyers write with such big ass words? Just tell me what you found, fuckers. It feels like I'm reading rocket science sometimes, dude. Like they put extra words in there, dude. All right. While preparing for this new trial, counsel for the defendant was going through call data record and cell site location information records provided by the state and discovery. The defendant's expert, looking at the cell records, commented that the phone records alleged to be Dontavius Withers and Christopher Thomas contains notes from a third party. Specifically, the last column of information provided by the state and discovery was not that type of information that he had ever seen on similar types of records, nor were the headers what he previously encountered. So Melly's expert for cell phone records is saying that there's weird headers and weird things on the cell records that they sent over, the papers or whatever. At least they're trying to defend the fucking cell phone records at some point. Jesus, they didn't do it last trial. Why was that guy not there the first trial? In fact, the expert was convinced these records have been tampered. Counsel for the defense contacted Bradley via email and informed her that the T-Mobile TrueCall records and timely advanced data record for 907 and the CDRs for Withers and Thomas did not appear to be original documents. In response to the email, Bradley responded by inquiring if the drive in possession of the defense counsel was corrupted. He responded by saying, is your drive corrupted? Is y'all's fucking hard drive fucking... That is actually the funniest shit I've ever heard, dude. Again, Miss Liberty told Bradley that she believed the cell phone records were altered. Bradley stated, I gave you everything I had. You are not getting anything else. Jesus. And then a week ago on October 24th, counsel for the defendant was speaking with assistant state attorneys trying the case at present. The prosecutors for the state informed the defense must have been provided with documents that had been worked on by Miramar, not the originals. So the new state attorneys a week ago told Melly's lawyers that it wasn't actually the original copies. That's a yikes. If I were to guess, they actually didn't change any of the data, but they probably just added shit, like for more context and notes, because it said third-party notes. And Melly's team is just nitpicking at anything that they think could be tampered, when it's probably not actually tampered, but it just... Why are they doing dumb shit? Like, what is the state attorneys doing, dude? One would expect that the remedy would be simply to provide the defense with the original documentation received by T-Mobile and Sprint, not with those that had been altered by Miramar State. However, this fails to take into account by the defendant's previous trial, which is said above, ended in a hung jury. Apparently, several violations occurred during the first trial. This evidence was not in the substantially same condition as it was when it was received by Miramar. Therefore, its admissibility into evidence was improper. A witness testified that it was substantially the same condition, although it was not. This tampered with evidence was sent back with the jury and reviewed by the jury during deliberation. Alterations of the original document prejudiced the defendant as the jury viewed tampered with evidence. What weight and influence it had on each juror is impossible to know, but it was viewed by the jury and should not have been. I highly doubt they fucked with the data, but yeah, this is what a defense team is supposed to do. They're supposed to nitpick little holes like this and be like, yo, y'all fuck with these documents. This can't be in this trial. In addition to this evidentiary violation, it had been brought to the attention of the defense team that the two files that are alleged to be the phone extraction of 907, the number they say is Melly's, which it is Melly's 100%, along with Williams and Thomas phone extractions are not phone extractions, but rather reports of the various parts of the phone, but not the entire extraction as the state presented to both the defense and the court. So they what? Why would they only present reports and not the full extraction? That's weird. Are they trying to hide something? Whether it be hiding Brady material, like I just said, covering up for lying officer, giving less than candid testimony at a hearing, providing evidence in discovery purporting to the original copies when in fact they had been tampered with, presenting the tampered with evidence to the jury. The state at each and every instance has acted in bad faith and attempted to thwart the defense due process rights. They go on to state a few cases where that could have happened. In other words, hand-picked messages, pictures, and videos were introduced which could have different meaning if presented in complete fashion. Since no true extraction was provided to the defense in discovery, the totality of prejudice cannot be quantified. Oh boy, dude. Melly's team found a nice little hole to just fuck. That's what they did, dude. All right, next, state's motion eliminate to prohibit defendant from improperly pre-trying this cause or making misstatements of law during voir dire. State requests the court enter an order requiring defense counsel to stay within perimeters of Hohan, Callaway, Blevins, and Vining, so 4 different cases. The court should therefore prohibit defendant or his counsel from referencing or questioning jurors regarding their feelings or thoughts on the specific aggravating and mitigating factors, and prohibit hypotheticals containing facts of this evidence or evidence to be presented. Okay, so that just has to do with the death penalty and just fucking with people's heads about, you know, putting someone to death, I think, because obviously there's type of people out there that will never put someone to death even if they think that they, you know, are guilty. It has to do with that. I'm not sure I understand completely, but whatever. I think mass shooters and rapists should be tortured so more people don't do them, because if that happened, then more people would be like, oh shit, yeah, maybe I won't go shoot out this place because I might get fucking tortured. Just a thought. I know that's probably an old-fashioned mindset, but you know, I said it on the internet. Fuck it. So apparently Mellys Mom talks right here for 5 minutes. Let's see if there's anything interesting in this.
Little update about, you know, what's going on with the jury selection. I chose not to go back to jury selection after the prosecutor did what she did. The judge did not ask me to remove myself out the courtroom. I love my son that much that I'm going to stay away from the courtroom until the actual trial starts. It sucks because I still don't have any phone calls with him.
That's kind of crazy, right? I mean, at this point, wait, no, actually he was trying to fuck with witnesses and shit. I suddenly remembered that apparently he was trying to fuck with, you know, his ex-girlfriend by telling her not to testify and talk to the police. So never mind, maybe he shouldn't get phone calls, or just every single one of his calls should just be monitored and he can't talk to fucking anyone besides his mom, right? That might be too difficult.
When you see something developing that way, when you already know that a department is crooked, you just remove yourself. That's a different type of love. It hurts and I'm sad about it, but I just rather not put myself in that situation or cause any delays in this trial or anything like that. Do I wish I could be sitting right there just so he can see me and I know it gives him comfort? Of course.
So I remember on the document, the prosecutor said that the judge basically told her to stay out of the courtroom, and she said, yeah, I will stay out of the courtroom. Like that, in a nerdy way, they wrote that out. She's saying that never happened. Interesting.
I'm not stupid, because for you to lie like that on me.
Oh, she's saying she lied about it.
Like, those are serious accusations. Like, I'm good on that. Like, I remove myself from any situation that could potentially cause me or my family or anybody, you know, to be just messed up. I'm not doing it.
Who knows who's telling the truth in the situation? I feel like she probably is, or his lawyers were like, yeah, maybe you should just stay away and be like, distance yourself until the trial starts so there's no more bullshit or issues just in case. I have a feeling that's what happened. The lawyers told her to stay away, but who knows what's true and what's not true. So yeah, that's pretty much it. Another motion to dismiss the entire fucking case. A motion to get rid of jurors that have, you know, researched the previous trial thoroughly, obviously. Jury selection and motions will happen throughout the month. So yeah, pretty much, you know, subscribe from Twitter and Instagram. I'll be covering this case. Love you boys. Peace out.